Welcome, everybody. It looks like we've got a lot of participants for the equine law section. This is a big event today, and with good cause. We'll give a few minutes for a couple more people to get in from the waiting room, and then we'll get started. All right, it looks like the increase in population is starting to taper off. So we'll kick off our event. I'd like to welcome everybody attending today, the members of the equine law section, and also the members of the fiduciary law section and the animal law section. As part of our stewardship to the bar, we like to make some events available to non-section members, and we're happy to do that with this one today. For anyone who doesn't know me, I'm Philip Burris. I'm the chair of the equine law section, and I'm so happy that you're here today. Before we get started, a couple of announcements. Our next event for equine law section members will be June 28th. It's Bob Webb from Frost Brown Todd, who's going to be speaking of hobby losses as they relate to equine activities. And it will also be our annual meeting where we vote on officers, slate of officers. We'll do that very quickly. The other thing, two announcements about this event. If you have questions, please use the chat feature, and you can type your questions into the chat and send them either to me or our speaker, and we will answer those as time permits. And CLE credit will be taken care of by Lane Sosby, who's so gracious to help us all the time. And so that will be taken care of for you, and you don't have to do anything. And with that, we got here kind of in a circuitous route, but I think it's a great thing for both our members and our guests today. And the fact that this is the second time we've scheduled an event on estate planning. The first one we had to cancel, but that sometimes you make lemonade out of lemons, and sometimes you find a pot of gold at the end of the rainbow. And we found a pot of gold because we have a great speaker here to talk about estate planning as it involves equines and pets in general. Peggy Hoyt is the founder of Hoyt Bryan, and she is an expert in estate planning matters as they apply to animals and horses, and has published a book on the topic called All My Children Wear Fur Coats, How to Leave a Legacy for Your Pet. And she even hosts a podcast by the same name, All My Children Wear Fur Coats. She's the chair, if I understand right, she's the chair of the Equine Law Committee of the Animal Law section, as well as we just talked about many other administrative roles that she occupies for the Florida Bar. And she's a member of the Florida Bar and in Florida. So we're happy to have her here talking today. She's a three-time graduate from Stetson University with a BBA, MBA, and JD. And she's also the founder of Animal Care Trust USA, which is a nonprofit that helps people as part of their estate plans find loving home for their animals. And Peggy, I can't thank you enough for being here today. I really am so happy to have you here. And with that, I'll turn it over to you.
Thank you so much, Philip. I really appreciate it. And also a shout out to Lindsay for all her hard work on setting this up. So it's my pleasure to be with you, the Georgia Bar Equine Law section. I am a horse lover. I have 4 horses of my own, 2 full size and 2 minis. And I'm going to introduce you to all my animals here in a second. But this is my passion, and the favorite thing that I talk about on a daily basis is helping people plan for their pets to make sure that no loved pet ever ends up without a loving home. And so this is why I do planning for pets. These are just a few examples. My little mini Dash and my service dog Abby that's behind me, and my little kitty Jenny, and my little mini Sparkle, and my horse Heaven, and my little dog Piper, who's actually sitting in my chair, and my dog Holly, and my cat Forrest, and my little Bingo, and Wolfie, and Blue, and Darla. And this doesn't even have my newest horse on there. Her name is Vogue, and she's being adopted from Horse Protection Association of Florida as we speak. So this is why we plan for our pets, because we have a lot of room in our hearts for our kids who wear fur coats, and we want to make sure that they're well taken care of. Horses in particular, because those of you who are horse lovers like me, you know that they can live an extraordinarily long time, and they are not inexpensive to care for. And not every single person would be a good choice to take care of a horse for you in the future. So we're going to talk about all the different ways that we can plan for pets. But as we jump into that, I want to talk about why pet trust planning is important within a broad view of multiple disciplines working together. So for those of you who are practicing in the area of estate or elder law, it's a good way to collaborate with senior care managers, with professional guardians, with hospice professionals, with both human and pet care death professionals, and then with all of the various disciplines within pet professionals. So I always have a marketing focus to things and have done a lot of teaching for lawyers on the marketing aspect. So I just wanted to point that out, that there's a lot of ways that you can incorporate planning for pets into your practice, as well as all of these other disciplines. But ultimately, in terms of planning for our pets, the overarching goal is to eliminate the 500,000 love pets that are euthanized annually because their pet parents didn't have a plan. The worst thing that I can possibly imagine is an animal ending up in a shelter, or for horses, even worse, ending up in an auction or a transported for slaughter to a situation that would be untenable for all of us. You know, we mostly think about dogs and cats in a shelter situation, but for horses, it can be so much worse. So I do want to bring to the attention of all these various disciplines what their role can be in the protection of love pets. And I also want to help create turnkey solutions for pet parents and family members and professionals, so that as they're providing advice to their clients or thinking about their long-term estate plans, probably all of you have some pets, and so all of these principles will apply to you, whether in your personal life or in your practice. I wanted to just touch base for a second on the numbers of animals that are in our homes and in our hearts. There's 90.5 million households that have at least one pet. So we're never going to run out of opportunities to educate people about the importance of planning for pets. And you can see the breakdown in terms of the number of dogs and cats and birds and small animals and reptiles. It astounds me every time I see this number, that there's more reptiles than horses out there in our homes. So I wish you reptile people would identify yourselves, because I don't know who you are that have snakes or other reptiles that they're providing for. But I do have clients that have planned for their turtles. So I think that that's a very admirable thing to do, because as we know, turtles can live a long time, turtles and tortoises. The Humane Society of the United States tells us that we euthanize 2.7 million healthy adoptable cats and dogs in our shelters each year. That's about 1 every 11 seconds. And although this number has gone down significantly over the last 30 years, it's still way too high. Total euthanized animals in shelters across our country is in the neighborhood of 3 to 4 million. Sometimes people say that they don't want to adopt a pet from a shelter because they want a purebred pet, and yet 25% of pets in shelters are actually purebred. I am adopting a Pasifino at the moment, and so she is a purebred horse that I'm going to get from a rescue, and probably easier to get purebred horses from rescues than maybe purebred dogs or cats. But my personal philosophy, and I'll share this with you, is until there are none, please adopt one, because not only are you saving the animal that you bring home, you're making room for another one to potentially have the opportunity to get a home. My dad actually coined that phrase. I was lucky as a little girl. My dad was the president and CEO of the Humane Society of the United States. So I grew up in animal welfare, and hopefully I am carrying on some of his good work on my own through my practice and through Animal Care Trust USA. I wanted to talk just a few seconds about the history of estate planning in pets, because interestingly, the idea of planning for our pets didn't start in the United States. It actually started in England, where the common law courts there actually favored gifts to support animals. And it really wasn't until recently, if you want to consider the last 100 years to be recent, but our first US court case was in 1923. It was a Kentucky Supreme Court case, which is really not their superior court, but one of their lesser courts. But it upheld the validity of a bequest to a trust for a pet, finding that it was for a humane purpose, and therefore they validated it under existing Kentucky law, where if you made a gift for a humane purpose, it could be upheld. Since that time, and starting in 1990, the National Conference of Commissioners on Uniform State Laws added a section to the Uniform Probate Code to validate trusts for the care of designated domestic or pet animals and the animal's offspring. Since then, most trust codes have also adopted provisions, but I am happy to report that today, all 50 states and the District of Columbia have pet trust statutes that allow for the creation of a pet trust, which would be a trust for the benefit of an animal beneficiary. And so there's no excuse for any of us not to be able to create a trust for the benefit of a loved pet. I like to point out that Minnesota was actually the last state who adopted a pet trust provision, and they finally did that in 2016. So time is marching on, and so now it's been 6 years since all states have had these provisions in their laws. I was lucky enough to get a client out of Minnesota, because Minnesota was so slow to adopt, who has become an excellent pet trust planning client for me, and just decided to use Florida as their choice of law for their pets. In terms of what the state pet trust statutes actually do, is they create the default provisions for pet trusts. So when a person tries to create a trust for the benefit of a pet, and if they do it a little inartfully, then this is where the state statutes might step in to fill in the blanks for interpreting what the terms of the pet trust might be. I would encourage you, if you are drafting pet trust, to try to be as expansive and broad as you possibly can in your drafting, so that we do not have to rely on the state statute provisions, but that we can draft our own provisions for how we want our clients' pets to be cared for. And just keeping in mind that you wouldn't want to include anything that would be against public policy or illegal. And if you just drafted to conform to your state statutes, it wouldn't necessarily include all of the provisions that would be important for protecting pets. And that's one of the things that we're going to talk about in more detail today. You may be familiar with the famous court case of Leona Helmsley, where she created a trust for the benefit of her dog, aptly named Trouble. And she left $12 million for Trouble's benefit. And there was a challenge in the New York state courts, and a judge substituted his or her judgment for Leona's judgment, and decided that $12 million was too much for a dog, and reduced that trust to $1 million. I personally have a problem with that decision, because I think Leona, as the owner of that pet and as the earner of the funds that went into that pet trust, should have the ability to decide what she thinks is a reasonable amount of money, and not have a court substitute their judgment. But you will find, if you look at the state statutes, that many of them do provide that a judge has the ability to determine whether or not they think that there's too much money in a pet trust. So this is one of the reasons why I usually caution my pet trust clients to name not people, but charities as final beneficiaries of pet trusts, because I think there's much less likely that a charity is going to challenge the terms of a pet trust than an individual. Not to say that it couldn't happen, but I think it's less likely to happen. The IRS, of course, they have to get their 2 cents in on everything. And so with regard to how they feel about pet trusts is they don't currently recognize a trust whose beneficiary is a pet, but because they don't want to miss out on the opportunity to collect taxes on the earnings of a pet trust, they have decided that for tax purposes, a pet trust should still be classified as a taxable entity under section 641. And as long as the pet trust is not invalid under state law, they're going to at least acknowledge that they would be entitled to be paid their share of the taxes due on the earnings on the pet trust. So I always say, as a result, pet trust income is therefore taxable, but unfortunately not at our pet's income tax rate, but instead at trust tax rates. There is no income tax or estate tax deduction that would be available for gifts to a charitable trust for the benefit of a pet if the sole beneficiary of that trust is an animal. I would say that many years ago, there was a bill pending in Congress. It was called the Morgan Bill. It was aptly named that after the drafter's pet dog, who was named Morgan. It would have amended section 664 of the Internal Revenue Code to provide for the creation of a charitable remainder pet trust. And unfortunately, that never got out of committee, but it is still my dream that someday we will have a charitable remainder pet trust under our Internal Revenue Code. And what that means is that any trust that we would create for the benefit of a pet that had a charity as a remainder beneficiary would qualify for that charitable deduction or charitable estate tax deduction. It has been estimated that somewhere between 12 and 27% of pet owners have included their pets in their estate planning. I cannot validate where that number came from, and I don't know how true it is. I hope that that number is growing over time, but one of the things we know about estate planning is that a majority of Americans have done no estate planning. So for those that have actually done estate planning, if they've included their pets, kudos to them. I will say that in my practice, 100% of my clients have done something to provide for their pets. It doesn't mean that they've all created a pet trust, but there are provisions in all of my clients' planning that are going to address how the pets are to be cared for in the event of the premature either disability or death of the pet parent. In terms of how we start the pet planning process, the first thing that I share with people is I think it's important to create a written action plan for your pets. And what this can include, it can be formal or informal, but the first and foremost thing that I encourage people to do is to identify at least 2 people. I call them your pet caregivers, to be responsible for the lifetime care of your pets. And it's important to identify these people both on a short-term and on a long-term basis. Because although you might have someone who can take care of your pet short-term, they may not be ideal for the long-term or lifetime care of your pets. So I think you need to look at it from both perspectives. I say identify at least 2 people. I think 1 is just dangerous. And ideally, I would say identify 3. And if you need to name an organization as your 3rd choice, then that would be a good backup to a backup plan. I also encourage people to assemble a notebook to hold important information and documents related to their pets. I have 2 such notebooks. I have one for my dogs and cats. I have another one for my horses. And in that notebook, I have a variety of instructions as well as the medical histories of my pets. I'm going to talk a little bit more about this as we go through the program today. I also encourage people to carry an emergency pet alert card. This can be something as simple as taking your business card and writing on the back of it who to contact in the event of an emergency because you have pets at home that need to be cared for, and carrying that in your wallet. I carry one in my wallet and it is right behind my driver's license. Another place to put that would be right behind your health insurance card, because if something happens to you, those are probably the two documents that people are going to look for. I also encourage people to post an in case of emergency decal or a sticker on your doors and windows at your house. One of my clients suggested putting one on your car dash. I thought that was a brilliant idea. I've actually thought about writing on the outside of my garage door that I have pets in my house, so that in case of an emergency, people would be well aware that I had 2 cats and 5 dogs in my house at any one time. Because what happens when emergency responders show up at our house probably freaks the animals out, at least some of them. Primarily cats would probably be freaked out, but they would hide. And then people wouldn't necessarily know that they were there or be aware that they needed to be found. And I know of at least one tragic story where a dog that was kept in an interior bathroom perished when there was a house fire because the first responders had no idea that there was a dog that was trapped in the house. So I think that's really important as well. And then of course, my pet passion is making sure that you include specific provisions for your pets in your estate plan. This would include both your powers of attorney as well as any trust that you would create. I'm going to talk about why I don't think wills are ideal places to do pet planning in a moment. The kinds of instructions that you should leave in your pet care notebook. I refer to these as babysitter instructions because you can put them on the same plane as the kinds of instructions that you would leave for a pet sitter or for a child care sitter. If you were leaving a child or a pet with a sitter for the first time, you would want them to know everything there is to know about your pets. Including their age, their breed, their gender, any identifying marks, their eating habits and food requirements, any special medical conditions that they might have, letting these people know whether they have any sensitivities or allergies to particular foods or medicines, any information that would be relevant regarding their veterinary care, who your choice of veterinarian would be, and then including only those special traits that you would know about your pet. I think this is an important thing to relay. My little dog Piper, deathly afraid of thunderstorms. So I think that's an important thing to point out. My little Darla, she's afraid of strangers. So that would be very traumatic for her to be approached by a stranger. I don't have any dogs that would bite, but maybe you have a dog that is an escape risk, where if you just open the door, they would be likely to run out and run away. I think those are important things to know as well. So anything peculiar about your pets that you would want people to know. Another example would be my little Darla is an indiscriminate eater. And so she has to be kept away from things that she might eat that are going to cause her to have tummy problems and end up in the emergency room. Important thing to know. And you can probably think of a lot more things that I haven't included here. I recommend to folks what I call a pet profile, a loved pet profile. And I can make that available to anybody if you're interested, and you can share that with your clients. My impression of what I would call a comprehensive estate plan for a pet parent is going to include a large number of things, but I warn people that I don't think it's a good idea to do any kind of estate planning yourself, but particularly pet planning. And I know a lot of people out there are DIY, do-it-yourselfers, especially engineers fall into this category, but I don't think estate planning should be left to amateurs. I really think that professionals need to be involved in this process. But for all of my clients, their durable power of attorney is going to include provisions for pet care. So the nominated agent would be able to make decisions on behalf of pets if that were necessary in the event of the disability of a pet parent. I also encourage people to include what I call a pet care power of attorney. This would be an instrument that would be specific to the veterinary care of your pets if you were leaving them in the care of a pet sitter. But it would allow your pet sitter to make those emergency care decisions for your pet if you were unable to be contacted in your absence. So as I've said here, they're ideal for pet sitters or short-term pet caregivers. Oh, I see a typo. Also, in your durable power of attorney for your healthcare, that's going to be important part of a comprehensive estate plan, making sure that you've nominated someone to make your own healthcare related decisions. A living will, which would be your end of life directive for how you want to be cared for at the end of your life. And then a pet trust for people who are serious about planning for their pets. And I say that pet trusts can really come in two varieties. They come in a standalone variety where you might have a single purpose trust for the purpose of providing lifetime care for your pets. Or you could have your pet trust be a testamentary trust, which would be a trust that would arise after the death of the trust maker. And also all comprehensive estate plans should include either a last will or a living trust or both, depending on your planning, and could also include charitable planning or other life insurance solutions for the benefit of your family and or your pets. One of the things that I encourage clients to think about is if they have limited resources for providing lifetime care for pets, that a life insurance policy might be the ideal financial vehicle for creating wealth for the purpose of funding a pet trust. Of course, you have to be insurable and you can't wait too long and you have to be able to afford the premiums. So there are some caveats that go with that. In terms of planning for your disability, the things that you have to think about are how your disability could adversely affect the care of your pets. So if you're unable to make your own decisions for yourself, how does that impact the care of your pets, and what decisions should be made for the benefit of your pets during a period of disability? I was talking with clients just this morning who are updating their estate planning, and they wanted to have some very specific provisions about how their pets would be cared for in the event of their disability, to go even as far as to say that if they were unable to care for their pets, that they may want the death provisions implemented even prior to their death to make sure that their pets would have a loving lifetime home. In the absence of creating a power of attorney that addresses the care for your pets, or in the absence of a power of attorney entirely, which a lot of people think about what happens if I die, but they don't necessarily think about what happens if I become disabled. So if a person becomes disabled and doesn't have a power of attorney, we would typically find ourselves in the guardianship court, where the appointed guardian would then have responsibility for the person and the property of the disabled person, the incapacitated person, or the ward. And I've gone on the speaking circuit years ago to the state guardianship associations to talk to professional guardians about pets and guardianships. And I think what you'll find is that most guardianship statutes do not address the needs of pets. They only talk about the personal property of the ward, and then the pets end up falling into that personal property category. where the guardian still has an obligation to protect, preserve, and provide for the property of the ward, but there's no guidance in those statutes regarding pets in particular. And many guardians are uneducated about that aspect of providing guardian care because they are not contemplating also caring for the pets. I know at least one professional guardian who had to go to court and request the court's permission to sell 2 champion mules that belonged to the ward, and they needed to be rehomed, and she wanted to make sure that that happened in a way that was positive for the mules as well as for the now incapacitated person. But don't look to statutes to provide the solutions there, because they typically do not. And then judges are really uncertain about how to treat pets in a guardianship as well. And can you imagine having to go to the court every time you needed to request an expenditure on behalf of the pets that could cause the costs of the guardianship to be excessive as well. So I don't like pets and guardianships. I'd prefer for people to use revocable living trust planning, have their pets as part of their revocable living trusts, rather than run the risk of ending up in a guardianship court. So in my living trusts, I do include specific provisions for the pets. So I'll use myself as an example. In the event of my personal disability, my successor trustee is instructed to use the assets of my trust, not only for my benefit, but also for the benefit of my pets and for the benefit of my spouse. And I always jokingly say, and not necessarily in that order, I would much prefer you take care of my pets before you take care of me or my husband. But I want to make it clear to people that my pets are part of that plan and that my successor trustee has the authority to expend trust assets for that purpose. I also have provisions in my living trust that say that I want to have access to my pets during any period of time where I would be disabled. I want to remain in my own home as long as I possibly can, so that I can have that continued access to my pets. And fortunately, many assisted living facilities today are allowing pets, small pets usually, not horses. When I visit assisted living facilities, I always make them laugh because I always ask where the stables are located. And I haven't yet had an assisted living respond that they actually have them. They look at me like I'm nuts, but that would be the case. I mean, if I was in assisted living, I would want my horses there if it was at all possible. In terms of planning for what happens when you die, obviously pets will be adversely affected upon the death of the owner if they are not properly planned for. I think the number one mistake that people make is that they assume that their family is going to be responsible for their pets. And I think that's a horrible assumption, because you can never, ever assume that even those people that are closest to you, your spouse, is going to be responsible for your pets. My husband would probably be disheartened to hear me say that, but I have seen numerous cases where animals were left to the surviving spouse, and the surviving spouse had no interest in providing lifetime care for those pets. And a lot of those pets came to an untimely end because they were either dropped off at shelters or, in a worst case scenario, prematurely euthanized by the surviving spouse. So I'm not willing to leave that to risk. I know my husband loves my animals, but I cannot guarantee what that future looks like without having provisions in my trust for what happens to their care. I always talk to clients about the future, who I call Bambi the bimbo and Biff the tennis pro. So those are the people that might end up in our spouses' lives when we're no longer there, and we can't predict what those situations might look like. So it's important to have trust provisions that contemplate the worst possible thing that can happen. I always say if my husband got remarried to Bambi, that she might say, I don't want to live in the country. I want to live at the beach. I don't like horses. I'm afraid of them, or I'm allergic to cats, or who in the world has 6 dogs? And I'm pretty sure that he could maybe be convinced that the other person's point of view was paramount to his. So I don't know. I'm just not willing to take that chance. So I say that there are lots and lots of planning options, which there are. What I see most common in planning for pets is an outright distribution of a pet to a pet caregiver. So that would be like me saying, I leave all of my pets to Philip Burris, and I expect him to provide them with lifetime care. Good luck, Philip. I think that has the greatest amount of risk because A, I've just left him all of my pets without any instructions. And B, did you notice I didn't leave him any money to take care of my pets? So he might say, thanks for the gift, Peggy. That isn't a very good decision. And he might dispose of my pets in a way that would not be consistent with my desires or wishes, just because either A, he couldn't physically take care of them, or B, he couldn't financially take care of them, or for other reasons. So I think there's a lot of risk in that. There's no oversight about what happens to the pets. The second riskiest thing is me doing that same thing, leaving all of my pets to Philip, but also leaving him the fine sum of $100,000 for their lifetime care. He might say, thank you for the $100,000, and I'm still dropping your pets off at the nearest shelter. So again, no oversight, no strings, if you will, to guarantee that the money that I've left for their benefit is actually going to go for their care. So that's where pet trusts come in, because a pet trust can really separate the responsibilities for the care of our pets. And it can be separated into potentially 3 different categories. Number one, a pet caregiver. So I might select Philip as my pet caregiver, the person who's going to provide the day-to-day care for my pets. But I might choose Lindsay Vance as my trustee, the person that I want to manage the trust assets, give oversight to the care that Philip's providing, and then make the disbursements of assets for their care to make sure that they are properly being cared for. If I want to go even one step further, I could create what I call a pet care panel or an animal care panel, which I might pick a couple of other people. I might pick Lane, I might pick Cynthia, I might pick Todd to also serve on a pet care panel to do double oversight, to not only pay attention to what Philip's doing, but also pay attention to what Lindsay's doing, so that everybody keeps everybody else honest. The other way your pet care panel could be appropriate would be not just for the oversight of the care, but if Philip becomes unable to care for my pets and I don't have sufficient successor pet caregivers named, the pet care panel could nominate a successor pet caregiver. They could also be in a position to nominate successor trustees in the event we run out of qualified successors. So there's really probably an unlimited number of options, but a pet trust is going to provide the greatest source of protection for your pets. You can then craft the kind of distribution and oversight options that you want to. There are many. I address them in detail in my book, All My Children Wear Fur Coats. And I talk about pet care panels. I have 2 pet care panels in my trust. I have, again, one for my dogs and cats, and then I have a separate pet care panel for my horses. Because although my horse panel people would probably know how to take care of dogs and cats, my animal care panel for my dogs and cats may not have familiarity with horses. Sometimes we don't have people that we trust to provide care for our pets, in which case we may be looking to organizations, either sanctuaries, perpetual care organizations, or an organization like Animal Care Trust USA that is dedicated to that oversight and the rehoming of pets. In terms of a testamentary pet trust, it would be part of that broader comprehensive estate plan that a person should have. I prefer pet trusts to be either standalone or as part of a living trust. I do not like pet trusts as part of a will. And my reasons have been validated for me because wills take time to probate. It often can take months now, given the court system, to even get someone appointed as the personal representative. And meanwhile, the pets are at risk because there's nobody that has any authority over the estate for the purpose of accessing funds and providing care for the pets. It's happened to me one too many times with even clients of my own, because when I first started doing pet planning, I sometimes let my clients convince me that they didn't want to do a full-blown pet trust inside of a living trust or a standalone pet trust. They just wanted a testamentary trust in a last will. I will no longer do that for clients. I don't think that they're effective. So I don't encourage them. I think that pet trusts should be created as standalone single purpose trusts or as sub-trust to a living trust. I think the other thing that we have to always think about when planning for our pets is not just who's going to be the pet caregiver or the successor trustee or part of the animal care panel, but what assets are we going to use to fund the pet trust, and then making sure that we have designated sufficient assets for the lifetime care of pets. And what is the correct amount of money to leave? The answer to that question is the same as the initials after our names, JD. It just depends. And it's going to depend on a lot of factors, not the least of which is going to be how many pets a person owns, what are the ages of the pets, what are the types of pets, and how do you want those pets to be cared for. I'll come back to that in a second. I think the standalone pet trust option is one of the best options that we can use because it is a single purpose trust and can be funded specifically for the care of our pets. It can be created during your lifetime, take effect immediately. You do have to make sure that you have assets that fund that trust, but they can be funded with a variety of assets, including cash, securities, bank accounts. Your pet trust can become the beneficiary of your retirement plan or your life insurance. And third parties could even contribute, or more than one party. So a husband and wife could both, or spouses could both direct their assets towards this standalone pet trust. Standalone pet trusts are typically grantor trusts during the trust maker's lifetime, meaning that any income that's earned on that trust would be reported on the grantor's income tax return and not require a separate pet trust return. But always pet trust should be part of a broader comprehensive plan. So how do pet trusts really work? Obviously, the trust maker is going to create the trust with the help of a qualified professional. The trust is going to identify the beneficiaries, the pets that are entitled to benefit from the pet trust. And I do this in a broad way because I want a pet trust to be sure to cover not just any named pets that I might have, but any pets that I may own at the time of my disability or my death, because the faces and the numbers are always changing at my house as they might be at your house. I want to make sure that I have sufficiently named a number of pet caregivers, both short-term and long-term, as I mentioned, with alternates. And I want to select individuals or organizations that I completely trust to make sure that those assets are invested wisely, that they are distributed according to the terms of my pet trust, and that at the termination of my pet trust, that they would be distributed to the remainder beneficiaries. I will mention that Animal Care Trust USA is the only US trustee that I know of that is dedicated solely to serving on behalf of pet trusts. One of the challenges we have when we name typical corporate trustees as trustees of pet trusts is twofold. Number one, they might have a minimum that is sufficiently high that we're not leaving those kinds of assets. I had lunch with a Wells Fargo advisor the other day, and their minimum for any kind of trust these days is $5 million. Most of my clients would not be leaving $5 million for the benefit of their pets. But even if their minimum was $1 million, many of my clients might not be leaving $1 million for the care of their pets either. So most corporate trustees would be knocked out because of their minimum trust funding requirements. And secondarily, my experience has been that most corporate trustees, although they love the opportunity to manage money, they have absolutely no interest in providing oversight for the care of pets. So that has consistently been a challenge and another reason why Animal Care Trust USA was created. I mentioned the creation of an animal care or a pet care panel. This would be appropriate if you want to provide additional layers of oversight. And then I talk about the homing options for pets. And I've created 3 categories. I call the first one Forever Home. And this is the one that I prefer. This is where your pets would stay at your home and your pet caregiver would move into your home. So I have that position available. And I think a lot of people would volunteer for that role because A, they get to come live on my farm and take care of my pets at no cost to themselves. So I identified this person who is my intended pet caregiver many years ago when she was 18 years old and an aspiring equine veterinary assistant. She's now in her 30s and is a well-qualified equine assistant and horse lover and dog lover and cat lover, and absolutely is on board to come live at my farm if something happens to me and my husband. Because not only is she willing to take on that responsibility, I have promised that if she does that, I will actually leave her the farm at the end of the pet's lifetime. So there's a big bonus in there. Hopefully she sticks around a lot longer than I do because she's half my age. But that's what I call Forever Home, where the pets stay at home and the pet caregiver moves in. Forever Family would be the rehoming of pets to another family or families that are willing to provide for their lifetime care. I have a golden retriever right now who found her forever family after her pet parent died. And the bonus for the forever family is that Dixie's medical expenses are provided for by the pet trust left by her pet dad. So it's a great way to have a dog and not have to be responsible for all of the expenses that go along with the dog. And this family would have done it without any incentive, which is lovely, but there is that added incentive of the pet trust. The third option is what I call Forever Sanctuary. And this is where you might have pets or animals that would not be appropriate for rehoming. And we can all think of animals that might fall into that category. Horses might go to a good forever home, but they might need to go to a sanctuary environment where they can live out their lives in a nice pasture, being cared for and being a trust fund baby. One of the things that I have done in my life is I purchased a farm in Virginia for the purpose of creating that kind of sanctuary for horses. I call it All Horses Go to Heaven. So if people have horses that need that forever lifetime placement, I know of at least one place and potentially many more that would be willing to take on that responsibility. Horse Protection Association of Florida is also willing to accept horses for lifetime care when they come with a pet trust. Your pet trust is obviously going to include instructions for the lifetime care of your pets. So I address all things from everyday care to critical care or care that might be required for a chronic condition. And then we also address what happens at the end of your pet's life. What kind of care you would want for them. Would you want them to be cremated? Would you want them to be buried? And what would you want that final disposition of their ashes to be? And then, as I mentioned earlier, I like naming charitable organizations as remainder beneficiaries because I think they are a lot less likely to challenge a pet trust. In my career so far, I've never had a charitable entity challenge a pet trust, but there's plenty of examples out there of family members who would like to bust the trust in order to get to the assets earlier rather than later. And as I said to somebody earlier today, I have a 1-year-old Minnie who could live to be 40. So my pet trust is going to last a good long time. And my nephews, if they were named as remainder beneficiaries, might not like that idea. So they are not remainder beneficiaries of my pet trust. I've said a lot about Animal Care Trust USA as we've gone through this, but it is a solution for pet trust, for pet lovers and their trusted advisors. We are a 501c3 charity. We educate pet parents and we provide those pet trustee services. And you can find out more information at our website at actforpets.org if you have an interest in learning more about what we do. And you could also read my book, All My Children Wear Fur Coats. It is available on Amazon. I am days away from releasing a 3rd edition if you want to wait for that. You can visit our website, legacyforyourpet.com. You can join us on our weekly podcast. And I appreciate all of you so much for your attendance today and for the commitment you have to horses and to animals and to educating other pet parents about the options that they have available in the world. So having said that, I see that it is actually 12:53. I think we have a few more minutes, right, Philip?
We do. We have a few more minutes until 1. Yes.
So I don't see any messages in the chat. So I either did a really, really good job or I've completely confused everybody.
I have one question while we're letting people type in their own. You mentioned the client from Minnesota who chose Florida as the choice of law. How easy is that to do in estate planning, in particular when it's your pets, to just select the choice of law that you want for your particular pet?
Well, I think it's fairly easy, save for the fact that there may be some connection with that state that would be required. Having a trustee that was a Florida trustee or having some other connection to the state, property in the state of Florida, or a financial relationship with the state of Florida. I think that becomes most relevant when there's the potential that somebody might challenge the terms of the pet trust. Otherwise, and that's a question we always ask in estate planning is who's going to challenge the terms of the pet trust. But that's an excellent question, Philip, and we may need to create those connections with the state so that we have that nexus.
Awesome. Well, I'm looking, I don't see any other questions. If anybody has one, now's the time to ask.
Jennifer does. Hi, Jennifer. See,
Unmute. Can you hear me?
Yeah.
Yeah.
I was typing it in, but I have 2 quick questions and a comment, and I'll start with the comment. You had talked about putting the alert cards in your wallet and that kind of thing. One of the things I was not aware of that actually my pediatrician did with my daughter's cell phone is, they have that emergency SOS medical information in your cell phone that EMTs can get to. I actually just added all of my pet info in there also with my emergency contact for who would come out to the farm to take care of the animals. So it's just another place that you can.
Excellent point. Thank you for that. I'm going to update the PowerPoint.
That's one of my questions is the PowerPoint available after this?
Yes, I will make it available to Philip as well as Lindsay. and they can share it with the section. And then I will also send them a copy of that loved pet profile if they want to share that with folks as well.
Okay, and then my other super quick question is, you had a stat at the beginning of the presentation. It was 500,000 loving pets are taken to humane societies. Where did that number come from?
So that's an estimate that was circulated by the Humane Society of the United
Okay.
States. I don't know how they validated that number or if it's just a guesstimate based on the number of pets that are euthanized annually in shelters. I mean, we know that there's some shelters that only accept love pets, and you know, some of those shelters are theoretically no-kill shelters. There's really no such thing as a no-kill shelter, because if animals are unadoptable or are ill, they might be euthanized. And so if we have the type of animals that really need that special care because they're seniors or they have chronic illnesses or they're of a breed type that might not be easily adoptable, I think it behooves us to do the best job we can to make sure that they have lifetime care. I have a client right now who passed away. I mean, she wasn't my client before, but now her family's my client. And unfortunately, she has a pit bull that needs to be rehomed. And there's no shortage of pit bulls that need rehoming. And so it's a really difficult situation. And I don't want her family to drop that dog off at a shelter, because I think it has absolutely no chance of survival. And B, I can't imagine, I don't want any loved pet to end up in a shelter environment.
Yeah. And then one other thing I thought of too while we were sitting here about the horses, I have a competition horse, and then I have just kind of a pet horse. For my competition horse, because he's valuable, I actually have a provision for him to be sold at an appropriate value, because he's, you know, him being in a pasture, he's only 5, would probably not be. And so that's just something else to throw out there on the horse side of things, is that horses, unlike dogs and cats, can be worth quite a bit of money that could be part of somebody's estate, that if proper planning is not done, somebody can be taken advantage of.
Absolutely. And that's a good point as well, Jennifer. I have clients who have competition quarter horses, and then they also have some pet horses as well, or horses that are retired from competition. And yes, we have included some very specific provisions regarding the resale or rehoming of the competition horses, and those provisions are different from how the pet horses would be handled. So thank you for that.
Peggy, we've got one more question. It says, where, in addition to the resources you've got here, where can we learn more about creating pet trusts? And this is a question from someone who's not an estate planner as such, but does handle simple wills and probate proceedings.
I mean, I don't know any other sources. I'm the #1 source.
Well, there's some good resources here. One other question just popped up. Do you ever have veterinarian serve as part of your pet care panel?
Yes, absolutely. We do have veterinarians serve frequently. They don't always want to serve. So you need to ask them in advance whether they're willing to do that. And then you have to be willing to pay them for their service, just like you would have to pay any professional serving on your pet care panel. But that's always a conversation that I have with people when they're funding the trust or deciding how much money to put in the trust, is we have to take into consideration the professionals that we might be asking to serve. I have a pet care panel right now where I'm on the panel, a veterinarian's on the panel, and the founder of a cat rescue is on the panel. So yes, the professionals want to be paid, and the founder of the cat sanctuary wants money for her sanctuary, of course.
That makes sense. Well, with that, I see we're right at 1 o'clock. This has been incredibly informative. I've got pet provisions in my estate plan, but after watching this, I need to go back and revisit them, because I don't think that they're adequate enough. But I can't thank you enough again for coming to speak not only to our section, but the fiduciary law section, the animal law sections of our bar. And if we can ever return the favor to you at your bar, we'd be happy to. But this has been an incredible presentation. We just can't thank you enough.
Yeah, you're all welcome to join our animal law section too. You don't have to be a Florida lawyer to be a member of the animal law section of the Florida bar. You can join as an associate. So
That's good to know.
we would welcome you to do that.
Great. Well, thank you again so much. Thanks to everyone that attended. This has been one of the largest CLE events that our section has done since it's been rebooted. And so I appreciate all of your time today. And Lane, I think with that, we're wrapped up.
Thanks,
Ladies and
everybody.
gentlemen, this does conclude today's meeting. Thank you for joining and have a great day.
Have a good day, everyone.